at holly@gieselfirm.com, and we'll try to answer any questions that you may have. So some necessary disclaimers, of course. This is it for education, not legal advice. If you need legal advice, hire a lawyer. What I'm going to say, although I am a member of the ACME board, my comments tonight in these slides do not necessarily reflect the views of some or any of the ACME board or any individual board members other than yours truly. This material focuses on adults designated with serious mental illness, charged with felonies and misdemeanors under Arizona law in Maricopa County. I'm not going to be covering federal or tribal law, and I'm not going to talk about juveniles or juvies as we call them, although former Judge Jim McDougall may be on, and he certainly would know a lot about the juvenile questions if any arise. It's too bad we're not going to talk about federal law, because in some ways the federal system for competency determination is really superb. And if you are fortunate enough to end up, unfortunate enough to, I guess, be in the federal criminal system, but if you are fortunate enough to be, you likely end up at Buckner Hospital in Buckner, North Carolina, which is a really superb psychiatric hospital with some of the finest practitioners I've ever encountered. So the federal system is different, and we'll maybe have some other time to talk about that. Going forward, so this is an interesting slide, which I came upon and wanted to look at because I think it really is the best horizontal presentation of what it means to go from entering into the system with an arrest all the way through to the corrections process. And it, I think, is very clear in the phases. The first phase being the entry into the system, the second phase being the prosecution and the pretrial phase that goes all the way up to the point of an arraignment. Now, it's important because, as you can see, most of the work in a criminal case goes on really before the arraignment, much of the time, with the prosecutors deciding, based on information submitted at the time of an arrest or in response to an investigation, whether to charge somebody. And in my experience, prosecutors take that decision extremely seriously. And they are not going to bring charges or charge somebody either in a complaint or go to an indictment, go to a grand jury to seek an indictment willy-nilly. They just do not. They give it great thought, and that's why there is a lot of that space that's there that's blue. Of course, then we go into the pink space, the magenta space, which is arraignment and then trial and then conviction, and over to sentencing, and then into corrections. So this is a pretty classical system that exists in any state. I think we have some out-of-state folks. I'm glad we do, because I think we can learn a lot sharing similar stories. This is the classic system, as I said, of a criminal justice system. But let's go back a little bit and look at something.
Hey, Holly, can we go back for a sec? We have a question that came in via text. So you mentioned that a lot of the decisions are made before they go to trial and sentencing. So how would a family best influence or try to tell their story to the prosecutor prior to the sentencing, with an attorney and without an attorney?
Okay. First of all, your opportunities to tell your story to the prosecutor really come, if you're a family member, at the time of some sort of diversion or deferral process where your prosecution is going to be deferred, if the case is eligible for that. There are many offenses that won't be. But the second chance that you have is through an attorney in the discovery process. When each side is sharing information, you want to be sure that your attorney or you give the prosecutor every bit of helpful, objective, well-founded information about your loved one's mental illness. medical records, reports, doctors, psychologists, therapists, peers who can talk about the family member and what in that family member's life led to this involvement in the justice system. So you do that very formally in the discovery process, and that kind of information is critical. Now, in the discovery process, that actually is going to be, that's going to happen over in here in the center part of the over when you get into the trial process, before, right in here in the adjudication, after arraignment, which is when you're going to do a guilty plea, you're going to have counsel appointed and so forth. It's going to be in this process. Some of it in, if you're dealing with a situation where your case may be, you may be eligible for diversion or for deferment, can come over here. And I want to get to the next slide and we'll talk about why that is such an important question, because it's at the heart in some ways of what the presentation is about. My family member who has mental illness has just been arrested. So let me go down here and we'll work up to this. You'll see this is a very poor quality slide, but it's because it's from a time, 1967, I was in the 7th, 8th grade, when we began to focus on criminal justice reform in this country under Presidents Kennedy and Johnson. So this is the first page here, but you'll see, look at this picture and look at the shapes. Remember what I just said about, we were looking at the prior slide, sorry. So look at this. Now look at this. You can see the similarities. We go over to convictions. So this slide was from 1967. The slide that we now use, which is an evolution of both of those when we're talking about mental illness, is the so-called sequential intercept model, which, and what I want to try to do here is to integrate the criminal justice system models, which we looked at here, this complicated slide, with the sequential intercept model. The sequential intercept model is simplified because it's focusing on points of interception so that we can hopefully go back and avoid a lot of this. So we're looking for the intercept points. And the first is initial detention, initial court hearings, and this line up to specialty courts. So if you get to specialty courts, one of the ways you get there is if the prosecutor and your lawyer, or you directly, can come to the conclusion, if you're eligible, depending on the crime that you've been charged with, or may be charged with, that you should not go into this so-called dispositional court down here. You should go to what we also call problem-solving courts or specialty courts. And we'll talk a lot about those a little later.
Hey,
So
Holly,
yep.
I have a question. What happens when in discovery process a public defender isn't correctly using all the information that the family provides to try to help their loved ones in the mitigation?
Sure. It's probably, it certainly wouldn't only be a public defender. I think all of us, private and public, whether you're state, county, or federal public defenders, do our best to try and inform and really work to get all the information out. The lawyer is in the best position to know what to use, when to use it, how to use it. But the family has to be an advocate, or the friend has to be an advocate for their loved one and try to make sure that all the information gets out. Now, there are some things in the system that are a part of our laws and the way we adjudicate cases that don't make sense, and certainly don't make sense to family members. For instance, someone, unless they qualify for being insane at the time of the commission of a crime, the fact that they were psychotic may not, in fact, have, unless they qualify as being insane, does not mean they're not guilty. It doesn't mean that it's a defense to the crime. And so that is hard for us to stomach, and it's hard to explain sometimes. But you should always continue to try to explain to your defense lawyer and in turn to the prosecutor why the information that you have, you believe, is important. And then it's up to the lawyers to respond in a way that explains to you, I understand you think that's important, but here's why it doesn't do what you want it to do, whether that is to usually as a defense. It undoubtedly can be useful in mitigation, and we're going to talk about that a little further down. So this is the current, it's a very good chart by the Maricopa County Attorney's Office, and it is the flow of a case in the MCAO, adult criminal system, for going through. So when we say, my family member just got arrested, the first question we want to know is, did they get arrested walking down the street? Did they get arrested with a warrant? Did they get it in a summons and something in the mail? Because that has a lot to do with the nature of the charge and the circumstances under which they were arrested. It's one thing to get a summons in the mail or to be, in a sense, ticketed for the common one in a lot of the nightclub areas in town is urinating in public. Well, so that's a misdemeanor, and they'll give you a ticket, essentially, or maybe you'll have to go to city court, and that's one issue. If you're arrested in the course of a huge fight, that's a different arrest and entry into the system. If they come to your house, knock on the door and say, we're arresting you on this warrant, which has been issued, that's another one, which would be coming out of a grand jury. So that is the first step. And as you can see here, there are different loops that go out depending on your arrest. Now, we've talked about charging, which is the center green box. You can be charged either by a complaint, which is filed, and that's to the right of the screen, or by a grand jury indictment. And either of those can come after an arrest, because you could have been arrested, as I said, at the fight in the playground, or when you're in a fight at home with family members, or maybe a case manager calls because you're destroying property in a clinic, or you're fighting or arguing or being assaultive to individuals in the clinic. Then you would get an arrest, and then we would come down down to the initial appearance. And from there, I want to go forward, and we'll talk about what happens if you're arrested in other ways as well. So moving forward, again, I want to start and talk about the intercepts 0 and 1 here leading up to that arrest. Because when we're talking about defendants who have mental illness, who are living with a mental illness, we often are dealing with someone, particularly serious mental illness. We are dealing with someone who is involved in the crisis care system, in community services, and often with local law enforcement on more than 1 or 2 or 3 occasions. So the key to the sequential intercept model is to prevent arrests by intercepting behavior that can be deemed criminal by someone who has a mental illness, and keeping it in these 2 blocks at 0, at intercept 0 and intercept 1. Now, an important point here for family members. If you have a family member who is not having a good day, perhaps even has become psychotic, highly anxious, or is very depressed, you're worried about the family member being a danger to self or a danger to others in the house, and you call 911, which I always encourage people to do unless they're hooked up very well with the crisis lines and a crisis care continuum through their clinic. I find that not often to be the case. But there are many good providers, many good crisis services out there. But much of the time, because of the nature of the behavioral health system, we are more comfortable and more accustomed to calling 911. So we call 911 and we say, my 29-year-old son is mentally ill. He's been diagnosed with bipolar disorder and he's really manic right now, or he's been diagnosed with something else. He's really psychotic right now. He hasn't been on his medicine, or she's taken, I think, an overdose of her medicine. Can you please come? And there's all this noise, racket, screaming, yelling in the background. The 911 operators do a pretty good job of asking questions to try and ascertain what's going on at the other end of that phone call. What exactly is unfolding in the house? And they will, depending on their assessment, get an officer there either, fast, quick, and in a hurry, as we say in the South, or they'll assign it a lower priority. It's very important if you're calling to report something involving your loved one and it's an acute situation, it's unfolding right now and you're afraid. It's important to tell the operator exactly what's going on. And if you can, ask for a mental health team or a crisis intervention team. I think all of the cities in Maricopa County and many around the state have completed CIT training in accordance with what's called the Memphis model out of Memphis, Tennessee, which is about an hour from where I grew up. It's a very well-known model, and the whole goal of it is to de-escalate, get situations under control, sort out what's going on, and avoid escalation, potential violence, people being arrested when it could be avoided, confrontations with family, etc. When I say confrontations with family, it seems to me it's part of our human nature, but it's unfortunate, and it's something I hope to always try to help people avoid. And that is, you're frightened. Your 6'4", 250-pound, 34-year-old son is in a closet. He's threatening himself. He's threatened family members. He has a knife. You don't know what else he has. Or maybe he has a weapon, a gun. They're so common now in so many households. And you're wanting the police to come and take care of him and get him out of the closet and get him help. Well, they come, and often the situation evolves. It becomes worse, not less, in part because there are often a lot of people in the house. They're getting involved. And if the police have to open that closet door and get that guy out, because he may be a danger to himself, they're going to try lots of ways to talk him out and so forth. But if your son comes charging out of the closet at the police, it often does not end well. We have to help the officers who are responding do what they can to help us. I think we really want the police to come. It's just when they have to do their dirty work, when they have to subdue a 6'4", 250-pound guy who's freaking out, it's not pretty. They're going to put hands on him. They're going to put him down on the ground. They're going to cuff him behind his back. There's going to be multiple officers involved, not just one or two, usually, maybe more. It's upsetting. It's heart-wrenching for family. And I always tell my clients when they come in and they're telling me all about this, I know it was horrible for them, but I also try to let them know that the police are doing their job and the family did the right thing, even though it may have seemed brutal in the moment or distasteful or ugly in the moment. The police are doing the work that we called them to do, which was to help us get our loved ones safe, under control, and to a better place than our house in a closet. I use that example because I've had that example in clients, and I think it's important to try and keep in mind that the police, you call them because you need them. They're there because you need them, and they
Oh,
do, in my view, the best they can.
Holly, we had a couple questions. One, I'll go back to something from Tamara later on, but another text came in. What if your loved one was very agitated, spiraling, and the police come, and now you don't want them to interfere? You just want them to go away. When you see the interaction, can you say, leave now? I mean, when do you cross that line where they say, no, we were called and we're taking them away?
Well, I think the answer to that depends. The short answer is no. You call the police are there to perform a public service. They're not like, as I've said, your lawn service. You call them to come mow your grass on Wednesday and you say, no, I think I'm going to wait and do it on Thursday. You've called them 911 and you have said there is an emergency at my house. They come, and their job at that point is to overhear, to begin. I want to go back. It's to begin this phase of investigation. You have called and reported something that may be a crime. You're asking for help. So at that moment, the police begin this critical phase, investigate. If you decide once they're there, well, I think that Bob has calmed down now and he's going to be okay. How would you feel if the police leave and Bob says, okay, in 20 minutes, I've had it, goes in, gets the butcher knife, and starts chasing his father down the street because he's decided he's mad again? I've had this case. Mom calls the police again. Police are on their way. Neighbors chasing. So dad is running from son with a knife. Mom is chasing son. Neighbor is coming out with a taser. Another neighbor is coming out with a dog. They're all running down the street. Things don't always work out like we want when we think somebody has calmed down. And I think the key words that this question used was spiraling and agitated. In my mind, for a police officer to respond, when a family member then says, oh, I think he's okay, and only 30, maybe 8 minutes before has called 911 and said, my son's spiraling and agitated, please send the police, for the police to walk away from that is unacceptable. They're putting everybody in that household and everybody else that person who's agitated and spiraling is going to come in contact with. So I think that's a failure to protect by the police. So this is what they're doing. When they're on scene, they're investigating. Now, they may decide, depending on what goes on in that interaction, to arrest the son. And whoever interferes, if things get dicey, they may arrest other people. That's appropriate. That's the only way that we can rely on our police to act in what they think, based on their training, education, their experience, is what is in the public interest and what will keep the most number of people safe. I'll go back and we'll go forward now. These are great questions and we'll wrap up a little later. Now, one of the things that I think is important is once we get to this arrest phase, right? That's when we're gonna go into the blue phase, which is where the prosecution is deciding what to do, and pretrial, all our pretrial services come to bear, and we'll talk next about that. But I want to show you, I think, the idea of the question that we just answered about the family that calls and then says no. This is really, and it's called the Goldstein Tangle. It should have a trademark pending note there because we have a trademark pending for it. But this was provided courtesy of Dr. Charles and Chuck and Laurie Goldstein. And this is something that Laurie created. Laurie's an engineer. And it is a wonderful example of showing, instead of those beautiful linear flow charts, that I've been working on up until now, working from up until now, I have never had a client with mental illness, particularly serious mental illness, where their case unfolded, particularly prior to arrest, in that nice linear way, with just 2 blocks of encounters and the crisis continuum system working great and everything being fine, and then they have one moment and there's an arrest. If you look at this tangle, find the point, the intersection point, where there are the most common interactions for this individual. If you look and count all the points of intercept, it's the police. 1, 2, 3, 4. So from my mind, when we're talking about individuals with serious mental illness and being arrested, this is the intercept that we have to work with. Critical. But what is also amazing here is that this is ping-ponging all around. And if you call the police because someone's agitated and spiraling, and then you tell the police to leave, and you say, oh, okay, I'm gonna get my child to go to the outpatient treatment, but doesn't have housing except with you, right back to where this intercept was. And I'm gonna get them to go inpatient, but how do I get him inpatient if my son doesn't wanna go? I can't get him unless I get him petitioned, remember, or I get a guardianship and I can have a little more control. But for the most part, this is a remarkable triangle. And I think it's important to see how few lines there are between the ACT team and the police, and how few lines there are from police to inpatient treatment. But this is the focus of most of our interaction before and at a release, and after, if our family member goes back into the community without more effective services than the family member had prior to the arrest. So let's look at this. We've been talking about these focuses. What I'm going to do for the rest of the presentation is have this little intercept model at the top of the slides, because I think it's helpful to keep in mind the points of interception that we are looking for. The community system of care and law enforcement are, in my mind, ground zero to prevent arrests for those individuals who have serious mental illness that is driving criminal behavior or criminality. We have to distinguish that from people whose criminality is primary and they have also mental illness, but their conduct, their criminal acts are being driven by criminality, not by their serious mental illness. So we've got kind of 2 populations. We've got criminals who have serious mental illness, and we have people living with serious mental illness who become enmeshed in the criminal justice system because they commit criminal acts. I represent folks on both sides of that scale, if you will. And I certainly don't judge either side. And when I say somebody has elements of criminality, I'm using a very specific term that's used in risk assessments and sentencings and things like that. So I'm not being pejorative. I'm just trying to distinguish the kinds of individuals that we're dealing with. The crisis care continuum, and here I'm focusing on screening agencies, the responsiveness of providers to families, back to the first question we had at the outset of this, their responsiveness to law enforcement, how responsive providers are in communicating follow-up so we don't have people fall through the system and end up spiraling and agitated, and the understanding of what it is to be a danger to self and a danger to others. I think Josh Moselle touched on the screening agencies, the responsiveness and understanding lack thereof on all 3 in his presentation last week about guardianships. But certainly I see this crisis care continuum as ground zero with lots of cracks in it. Huge cracks, huge gaps. Dr. Michael Franzak has said that the continuum of care is really a series of bridges, swinging bridges over a canyon. I think the swinging is most dramatic and the canyon is deepest when we are dealing at the outset of the system with people who have behaviors and experiences that indicate they are highly likely to have multiple engagements with the police, as the Tangle showed. One of the disturbing things we're seeing now is the second point, with behavioral health providers calling 911, officers come and they report an assault. And so they get the individual arrested. I have 3 clients now from ASH who have 3 individuals who've been arrested out of ASH, and they take them down and they go to court. They get charged for they're in municipal court. One individual was arrested, spent 5 days in jail, or 4.5 days in jail, no medication, and had to post bail. The IA judge obviously did not understand that this person is going to be at ASH for decades, and all they needed to do was get him back to ASH. He really wasn't a flight risk. If he could have run away from ASH, maybe he would have run away 20 years ago. But it was a bizarre case, but we are seeing it more and more. The other,
one thing for those that don't know ASH, it's Arizona State Hospital.
Yes, Arizona State Hospital. 3 hospitals, or 2 hospitals and a treatment facility. There's a civil hospital that is for civilly committed individuals. There is a forensic hospital. Virtually everybody is guilty except insane under our current statute, and they're doing their commitment in the hospital, not in prison. We have a few people who are still from our old not guilty by reason of insanity statute. We don't have that anymore. And a very few people from out of county, other than Maricopa County, who are there for competency restoration. They've been found not competent. But the third issue then going ahead is individuals living with chronic serious mental illness. They are maybe treatment resistant, they haven't found the right program, or the programs can't accommodate them. And so they are often homeless. And we in Arizona, in Maricopa County specifically, have an inadequate number of beds and an inadequate number of settings that really do an adequate job of providing this care continuum. And so these individuals who are on the streets or in and out of temporary housing are highly likely to get justice involved, unfortunately. And we'll see that later in some statistics. But this is ground zero, and it's where I think we have the greatest potential to say, my loved one hasn't been arrested in the past year, or hasn't been arrested even in the past 6 months, or that's where we want to get, and that's a powerful fulcrum for change.
2 things, Holly. Question back there in that last slide. Is there a role for the police to divert to special SMI services? So before they arrest, do they have any special authority to try to start a diversion?
Well, they have powers that they certainly are permitted. They make the decision about whether to arrest or not. That is their decision based on a report, an observation. Did they see somebody commit a crime? Or is there probable cause to believe they committed a crime? And what does their investigation tell them? Back to the investigation block. They have a 2-way street in Maricopa County with crisis care, with the crisis care continuum. In one very well-known case now, a case involving Curtis Bagley, it's been all over the news, the Phoenix police had petitioned him multiple times over a 2-week period. They kept taking him. They didn't arrest him. They could have. They gave him a ticket for trespassing in an alley. But every time they encountered him, those officers put him in their car, gave him water, took him to one of our screening agencies, and over a 2-week period, not a single screening agency kept him for more than a few minutes or a few hours, or in one case, a few days. But they discharged him ultimately, concluding that his problem was primarily substance abuse related. In that case, the people who got it right, and this is one reason that I have it right over here, the people who saw exactly what was going on and what needed to be done, which was a therapeutic intervention, was law enforcement. The people who didn't, who missed the boat, and it was a big giant cruiser, it wasn't a little canoe, everybody could have seen that this was a disaster that was going to happen. These guys got it right, these guys not so much. So the police have a valuable role to play there, and they are doing it more and more and more. So why do we care about the arrest? I mean, after all, you can stay in jail maybe, you're gonna have, you've got a whole lifetime ahead of you. Well, in Arizona, my friends, a felony conviction is a lifetime game changer. We have a very tough criminal code with very long sentences. It's not unusual. You can easily see a sentence in Arizona and a comparable crime in another state, and ours is going to be 25% longer. We have sentencing by chart. We have a sentencing chart that puts your history, the nature of your crime, aggravating and mitigating circumstances, and the judge can't go outside of that chart. They can have a mitigated sentence, a presumptive sentence, an aggravated sentence, or a super mitigated and aggravated. But we have minimal judicial discretion in sentencing. So it's very black and white. And when we are dealing, I think we all know, with individuals who have mental illness, serious mental illness, we really can't just deal in black and white, but that's what sentencing does. In Arizona, a mental disorder is not a defense to committing a crime. The fact that you were psychotic does not mean, in fact, the Supreme Court in the Clark case says that your mental illness is not a defense and doesn't negate the mens rea for committing a crime. That means the mental state, you intentionally did something or you knowingly did something. The only thing you get in Arizona is you have to admit to being guilty except insane. We no longer have not guilty by reason of insanity.
So Holly,
Yes.
for those of us that don't speak the legal jargon, can you give a clear example of what you mean by guilty except insane and having the right mindset at the time, knowing right?
Sure. A classic example would be you were in a let's say you have a diagnosis, you're living with schizoaffective disorder, and you become psychotic. You're in the middle of a psychotic break, and your psychotic break is such that you did not know that you were stabbing a person and that was wrong. You thought you were swatting a hornet that was going to sting you. But that's how significant your mental illness has to be, and the degree to which it impairs your ability to know what you are doing is wrong. And it must come out of a mental disease. People use different terms, but it's a disorder. So that would be a good example.
But how can they prove what was in your mind at that time, other than them asking? How do you prove that?
Sure. Well, the first issue is, do you prove it to a judge or a jury? The answer is maybe both, either a jury or a judge can find it. We use experts. We have experts who evaluate the defendant, evaluate their mental illness, evaluate their functional capacities, evaluate a whole range of highly clinical issues, and the expert opines to a reasonable degree of medical probability that this person had this disease, which had this effect on their ability to form the mental state required for a crime, and the act that they did not know what they were doing was wrong. So it's all about experts. These can be quite complicated cases. The good thing is, if you are found guilty except insane, you get to go to ASH until you are released by our Psychiatric Security Review Board on a determination that you are in stable remission from your mental illness, which is a term that has never been defined in statute. It is not defined in statute. The PSRB uses the term, and it's sort of like they know it when they see it, but it is not defined. But they decide you are in stable remission, no longer dangerous, and they look at propensity to reoffend. And then you may get privileges and ultimately be released. Now, I put on the slide ASH, not prison, or both, because if you are convicted of certain dangerous crimes, then if you are released from ASH prior to the expiration of your sentence for the crime that you would have been sent to prison for if you hadn't been found guilty except insane, then the state can send you to prison. So if you're convicted, if your conviction was, say, second-degree murder, and your sentence would have been 25 years, which is a long time, but let's just use that hypothetically, and you're at ASH for 15 years, which would be quite typical, and they say you're ready to go, you're no longer dangerous, you are in stable remission, the state of Arizona can send you to the Arizona Department of Corrections for the remainder of your sentence, had you not been guilty except insane, which in that case would be 10 years. So it's still, in most people's mind, better to spend your time at ASH than in prison, where you surely will not get the kinds of treatment that is available at ASH, and would live your life with a serious mental illness and a period of insanity, which is tragic. Now, there are a final point here. In Arizona, we have huge fancy words, collateral consequences, by which I mean bad results in other areas of your life if you are convicted of a felony. If it's a domestic violence or sex offense felony, you may have to register and be on probation. If you're sex offense, you may be on registration and probation for a lifetime. Domestic violence, you may be on probation for a very long time, 10 years. In many pleas here, you lose civil rights, so your right to vote is suspended, for instance. And Arizona has set-aside statutes, meaning you can get your conviction set aside after usually a fair number of years and a lot of demonstration that you're a different person, a changed person. But there is no expungement. In other words, you can't wipe the slate clean. These have all great consequences on employment, on where you can get housing, on whether you get employment. So these are major, major changes in a person's life, particularly if someone is living with a mental illness. These are additional burdens to their recovery. It's like, instead of lightening a backpack, when you have a felony conviction, we put more bricks in your backpack to make it harder and more difficult to have a recovery and be in and live in and among and work with all of the rest of people in our society. So it's quite burdensome. Here's another, I want to use these two slides because we're now talking about just when you've committed an assault and the dangers in this period where we've got the interaction in the community and the police. So simple assault in Arizona, misdemeanor assault, you intentionally, knowingly, recklessly cause any physical injury, or you intentionally place another person in, and this is very key, reasonable apprehension of physical injury, or you knowingly touch someone with intent to insult. These are pretty broad terms, but you can see it's a very broad, fairly not as specific as we might like.
So Holly, can you give us an example of what number 2 and number 3 would be? Number 1, is that a fight? Is number 2 in a car going too fast? Is number 3 bullying on the internet? I mean, what are examples of these?
Well, touching is, and recklessly causing physical injury wouldn't be internet. I don't believe they would charge misdemeanor assault on the internet. There are other things they're charging with internet crimes now. Placing another person in reasonable apprehension, number 2, would be you go up, you're having a bad day, you're agitated, you're spiraling, maybe you're a little paranoid, and you think somebody is watching you in a restaurant. And you go over and maybe you move their chair and you get right down in their face and you point your fingers in them and maybe you threaten them. And it's obvious that you did it intentionally because you say, I came over here to tell you, stop looking at me, on and on. That could be it. Knowingly touching another person with the intent to insult, injure, or provoke. Well, I have a case. Young man is on the bus. He's talking to some girls. They are younger than he is, much younger. They're minors. He's in 29, they're teens. And as one of them is getting up to leave, he's engaging with them and he strokes her hair and tries to put his arm around her. Is that an assault? What did he intend? Well, they charged it because they thought that he was doing it to insult her or to somehow provoke a reaction from her because she started ignoring him. It's a sad case because it then got later changed. They added sex assault. So it's even a more difficult case. So moving forward, here's what happens depending on the circumstances. Back to what we talked about when the question was about the police coming and the family member not wanting them to leave, and saying, I don't really need you, leave. Well, it doesn't take a lot in Arizona to get aggravated assault. I see this as one of the most overcharged crimes that we really see, and here's why. It's aggravated assault is everything that we had in simple assault, okay? We just were here, 1203, so it's these 3 things, but you can get aggravated assault and the penalties are draconian depending on what you did, who you did it to, where it happened, and what else was going on. So what if you cause any serious injury? A serious injury can be a black eye requiring you go to the hospital. It can be any injury if the victim has any disfigurement. So stitches, a cut lip, stitches. Who? Well, we have a long list of people that if you commit what's a simple assault, it becomes an aggravated assault. Peace officers, that's police, fire, first responders, sheriff's deputies. It's everybody who works as a correctional officer. It's prosecutors, defense lawyers, teachers, etc. It is a long list, so that we took simple assault, we added 11 items and a bunch of sub-items, and that becomes aggravated. There is an important protection here, and that is that a healthcare practitioner, okay, under 32 and then 13, 15, 17, these other chapters, who's engaged in the person's care. This subsection doesn't apply if the person who commits the assault is seriously mentally ill, as defined in 36.550, that's our SMI definition, or is afflicted with Alzheimer's disease or related dementia. So now these are nurses, doctors, social workers, etc. But who is the one who's most likely to get involved in a tussle with a patient in a clinic or in a facility? It's not those providers, it's your security people, it's your behavioral health techs, it's the nursing aide, it's the receptionist. And then this exclusion doesn't apply. So that's an interesting exception. The other issue is, look what's omitted. Autism is omitted. Serious cognitive difficulties are omitted. Developmental disabilities are omitted. And Alzheimer's disease or related dementia, and that's litigated. What was this related? Was this dementia related to Alzheimer's? What about people with traumatic brain injuries? So you see how important it is to have statutes very clearly written, but the exclusions sometimes are where, in fact, the real problem is, as we note with the behavioral health techs or security and so forth at facilities. Where, if you have a simple assault in a jail or a prison on anyone, any official, any person acting in their official capacity in a jail or correctional facility, it's going to be an aggravated assault. Now remember here, we're also talking about intentionally placing them in reasonable apprehension of imminent physical injury or intending to insult or provoke them. So name calling, pointing your finger at a prison staff person, we see these things, and it's very frustrating. And
what can families do? I mean, we have a question saying you talk to the prosecutor, you provide a defense, that's what families do, and you're hearing about this poor guy getting charged with sexual charges because he hugged or touched someone's hair and shoulder, and they assumed intent.
That's right.
What can people do to prevent this from having, escalating and getting expanded charges into sexual assault when it's likely that wasn't the intent?
Right. Well, you have to work after the fact, after the arrest, after the charging. You have to work with your defense lawyer and work with to the extent that the lawyer can with the prosecutor, and to try and get a different look, a different understanding of what the conduct meant, why it happened, and what can be done about it. I will say that compared to 5 years ago, certainly compared to 10 years ago, but even in the last few years, the prosecutor's office in Maricopa County has become, at the individual prosecutor level, so engaged for the most part. Now, you always have some outliers, some folks who are just going to be really hard-nosed about everything, or they're very young and they don't have the insight yet to wrestle with cases and try to work it out. But for the most part, the prosecutors that I interact with, there is a sea change in trying to look at cases like we've been talking about, and all cases with serious mental illness, with a different view. Now, and we'll talk about this later, remember, only the county attorney in each county, it's a statute in Arizona, the county attorney is the person who decides who can be diverted and who can get deferred prosecution. So diversion, deferred prosecution are a matter of policy and guidelines within each county attorney's office. And they vary across the state. What happens in one county would not be permitted in another. So in an election year, that's a way of saying elections matter, right? Who we elect as a county attorney, and their approach to mental illness, their pragmatic approach is critical. The last county attorney, Bill Montgomery, put in place the FPIP program, which is the first program for, there's FPIP, which is felony pretrial intervention, and then there was the SMI FPIP, which went in as a beginning program. And I was thrilled to see that. And of course, Mr. Montgomery actually attended a couple of the ACME board meetings and was very engaged in how mental illness would be handled going forward, and what the system could do about it. So I think that we have to be engaged in public policy. We have to get with our elected officials and officials who are running, try to engage them in this. And then once a case is there and we're dealing with it, you've got to get with your defense lawyer and make inroads to, as much as you can through that lawyer, into the prosecutor's head and into the way they're looking at a case. And we're not talking just giving them your thoughts. I'm talking 3-ring binders with reports, with documentation, with statements from providers, statements from their treatment team, especially psychiatrists, psychologists, social workers who are dealing with this person on an ongoing basis. And with that kind of hard evidence, we can make progress in these cases. I'm convinced. It's not perfect. There's still a horrendous amount of injustice, but we're getting better, and we're a long way from where we were a short while ago, frankly. Moving on. So we've talked about what happens at leading up to an arrest. What are the 3 things you should never do if you're going to be arrested or somebody else is? Well, the first thing is don't run.
Well, remember the chart you showed? Our loved one always ran, and he was usually just being picked up, amended for behavioral health and court-ordered treatment, but he always ran.
Of course.
He got tackled a lot and tased a lot. And I said, when the police say stop, stop.
That's right. So don't run. Your point is my point here. You won't make it. You will get caught. You will either get caught by the cops, who are very fit and their job is to catch you, or you might get worse than that. You might get tased, or you might get a dog bringing you back, but you will be brought back. You add charges. And most importantly, you look guilty. You know, when you run, and this is, it seems it's hard to explain this to people, particularly it's hard to explain to an individual who says, but I'm not mentally ill. I don't have mental illness. I don't need that. I just have bad days, sometimes bad weeks, sometimes bad months, but I'm not really mentally ill. It's difficult. So what you don't do, you also don't touch an officer. Don't walk up in your house when the officer is talking to your son that they've just dragged out of the closet, and walk up and grab his arm and say, please don't, or please let me explain. That's a no-no. It is as much a no-no as putting your hand on a hot burner. And don't spit, throw water, kick dirt, etc. Remember, that's going to result in an aggravated assault, because it's going to intimidate that. The officer is going to say that was an intent to insult and so forth.
Would the family member that said stop and touch the officer, would they get arrested possibly?
They certainly could. Absolutely. Absolutely. And I don't blame that officer, because if I'm there bending down with 2 or 3 of us trying to subdue this guy, and somebody comes up and grabs my arm, where's my gun? My gun's right below my arm. Are they grabbing for my gun? Are they grabbing for my taser? Are they trying to grab my cuffs off my belt while I've got this guy down? That is something you don't do. It is as basic as don't go pet a dog who's eating their food. They don't know you're doing that. And I'm not comparing an officer to a dog eating their food. This is a moment for these officers where they are there to try and prevent injury to other people. And while you may be very well meaning in going up as the officer is bending down and putting your arm on his back and saying, can I talk to you? Can I have a word with you? I want to explain. That officer doesn't know that when you touch him. And it's just not wise. Never do it. And never interfere in an arrest in any way whatsoever. Wait and let the situation get under control. Let the officers finish up what they're doing, then have a conversation. And they will converse with you. But when they are in the middle of executing an arrest, particularly if it has involved a takedown or they've had words or had to put hands on an individual, walk away and let the situation calm down. So upon arrest, if you're arrested or your loved ones, 3 things to always do. And this is going to sound touchy-feely. It's going to sound like I'm quoting, mindfulness or something. Breathe. You've got to step back and get your thoughts and your emotions collected and just take a few minutes to focus on this whole circumstance. Then focus on your next steps, assuming your loved one's been taken away or you get the call that your loved one's been arrested. Contact your attorney if you have one, or I'll tell you later how the system plugs in. Contact your support system. Now, I almost always put a little question mark here because some support, a local psychiatrist, I won't use the name, in a meeting that I was at once said, yes, but not all families are healthy, which I think is just wonderful, right? Of course we aren't. And sometimes our support systems are part of, they can be wonderful, they can be helpful, but they can also be enabling and disabling in times of crisis. So we have to really pick who we choose to rely on. And finally, contact the clinical team. If we go back to the first up here, this crisis care continuum, that's what they're there for. That's what the crisis lines are there for. Be on the phone immediately, trying to get your clinical team involved in telling them that an arrest has occurred. And last, the third point here, prepare yourself for uncertainty and frustration, because there's going to be plenty to come as we get and move through that legal system. Now, the first step, assuming an arrest has been made, is initial detention. It's now at 4th Avenue Jail, but I don't know if people know, we have a new $185 million, 500,000 square foot intake, detention, transfer and detention facility going in at 29th Avenue. The groundbreaking ribbon cutting was in February. The opening is delayed. It replaces Durango Jail, which is way past its useful life. And it replaces all of the non-jail, all of the non-custody services at 4th Avenue Jail. So booking, mug shots. When you come in, you're going to get booked, quote unquote. You're going to get your mug shot taken. You're going to have a nurse-conducted health screening, an examination, health examination, if it's necessary. You're going to get classified. A custody level is assigned, and then they'll know where you'll go in terms of all the different jails, depending on that custody level. Custody level is determined by the nature of your crime, your criminal history, and other factors like your mental health status. And if you have urgent needs, healthcare needs, you will get those PRN or as needed. Now,
so Holly, when
yes.
you say that, based on your health, so if you have a broken arm, you get that taken care of. If you are currently on an ACT team or currently on a case managed. Do they know that? Is that in their systems?
They're screening, well, there is a data link. So they should be able, once they have your demographic information, they should be able to determine that. But their intake screening questionnaire, their health screening questionnaire, and we can put it up on the ACME site, ask questions about your health status, if you have been diagnosed with mental illness. It also, who your providers are. But not everybody knows that, right? Not everybody can recall it. Not everybody's willing to share it. Some people may be frightened to share it. So they have to rely on the data link down the road to get that information. Also, there is now an outreach program where the jail communicates to the clinics if a member has been identified and come in. So that's good. Now, when you learn that your loved one is there, you can start trying to reach them, but that is reach the health team down at the jail, and that's Correctional Health Services, the legal liaison. But it's very difficult during this booking phase. Now, your initial appearance must be 24 hours from the time of booking, or they have to let you go. I've actually had, I was a victim of a crime where somebody smashed the window in my car and took my camera out, which I foolishly left lying on the seat. He was arrested in Tempe. They didn't get him down to get his IA for 26 hours, and they cut him loose, as they should have. But at your initial appearance, the commissioner is going to tell you, well, this is what the police have as charges. This is not the final charges at that point. All the commissioner is doing is reading the police report and particularly paying attention to what is called a Form 4, which has the police's, the arresting officer's probable cause statement, which says what he saw, what happened, what information he was given that caused him to arrest your loved one. This is a critical document in the criminal justice system. Now, bail will be set and your release conditions will be specified. We have had a great deal of progress in recent years, the past few years, in people being released on their own recognizance, even out-of-state defendants. Even out-of-state defendants who had gotten charged with fleeing and with assault, and we'll come back and talk about that in a second, but they also specify release conditions. So you can't go back to maybe the scene of an incident where there's a victim. You have to.
Okay, so Holly, on this one, since you're talking about bail, should family members bail family members out and loved ones out? Is that always the default condition? Should you bail people out?
I have a slide on that. So let me come to that. It's a very good question, and I think it's a mixed bag. Now, if your loved one is at the initial appearance, and we're going to give you the IA court's current phone number, you can call down and say, when is my loved one, when is Joe Smith, date of birth, etc., going to be have his initial appearance? And they can tell you. It's a 24-hour court. They have 4, 5, or 6 court appearance slots with 8, 10, 12, however many people are being IA'd that day. And it's for all Maricopa County arrests, for the most part, in Phoenix, for the city of Phoenix. The other court, city of Glendale, for instance, does their own IAs. And you can be arrested, for instance, at Glendale. I have a client just came in. A daughter was arrested at Glendale at 4 o'clock in the afternoon and stayed overnight in the Glendale jail with none of the things that you get up here. This young woman is 18, and she has not only serious mental illness, but some other illnesses like autism. And so that's very challenging. She spent all night in Glendale in a cell that jail is notoriously dirty for the IA people. And she finally was IA'd the next day. Remember, they've got till 4 o'clock in the afternoon, roughly. And then they got her out. If you're downtown and 4th Avenue and in the new facility, it's video viewing only. It's currently in the Bonds and Fines lobby, which is on Madison. There's a private room for victims, but you can't have contact with your loved ones. You can barely see and hear the TV, which is mounted up next to the ceiling. And we're going to put the current IA phone number on the website. I'm going to give you a whole list of phone numbers and email addresses and so forth. I simply didn't get it finished.
Okay, one question, Holly. We have 2 that came in.
Uh-huh.
How do you get your loved one's medication when they're in there? And the second one is, where's the justice because of COVID? Our status and hearings keep getting pushed back. So
yeah,
is it okay because of the pandemic to not have these well-defined times adhered to?
Well, let me talk about the meds first. You cannot take meds to the jail in a brown bag or a nice container, any kind, and give it to the jail and ask them to give it to your loved ones. They're not going to do that. What you can do is get in touch with your care team, first of all, have them reaching out and reaching in to the jail to tell them. And you can call the clinical liaison for correctional health services. There is a director of mental health services, and there is a medical director. And I would call all 3, and I would send an email to the legal liaison, and then I would be asking my clinic team to be right on that, because you don't want that to happen. My patient from the ACPTC at ASH, that's the Arizona Center, the Community Center for Protection and Treatment, that individual was there almost 4.5 days in acute withdrawal from a number of medications. Not pleasant. Now, importantly, this is the first opportunity for diversion, because the person, although they've been booked and there's a police report, they've been arrested, the police have said there's probable cause, they've not yet been charged by the county attorney. So diversion is typically pre-charging. That's what in theory, that is what it narrowly is defined as. But this is the opportunity, and this is where some of our mental health courts are now having the opportunity to have this early referral to a mental health court or to one of the specialty courts, including the EDC, the Early Disposition Court, which is is a common place for lower level drug offenses to be, and many individuals with mental illness are oftentimes in that. And that's a kind of new court that we haven't had. But IA is considered a specialty court. All of our specialty courts now, by the way, are under Judge Starr, and she is wonderful. She was involved in rewriting the rules of administrative hearings, the JRAD rules and the judicial review of administrative decisions. And she is very thoughtful and very attentive, and is really, I think, going to be great for all of the specialty courts, including the mental health court, the drug court, and so forth. Now, 3 challenges when a loved one is jailed. And I always use 3 because I can't remember anything that's got more than 3 parts to it, right? So I just always boil everything down to 3. The 3 challenges you have, whether your loved one is jailed for 1 day or a week or a month or a year or a decade, is you have almost in jail no physical access anymore There is no in-person visitation for families, and you have very limited communication. A warning, all telephonic and video visits in the jail with families, everybody other than a lawyer, is recorded. I have a client now who is in custody in a different county, talking with his parent about the evidence in the case and telling somebody about other more damaging evidence that needed to be dealt with. Yes, it's recorded. It comes out. And it's unbelievable how many times families are talking on the phone, and what goes on is not helpful to that side of the case at all.
So basically, you're saying never discuss the details of the case on the telephone.
Absolutely nothing. Nothing. Your attorney has confidential communications. You do not. And anything you say about the case is not going to help. It will hurt. So the next challenge is parents and family members have enormous uncertainty. They feel guilt about their loved one's fate and what could they have done to better deal with the mental illness. They are fearful about jail, all legitimate concerns. You cannot minimize any of this. The question then, do we bail them out or not? For most people, the first issue is going to be finances, even if it's a $5,000 bond or a $2,500 bond, let alone a $10,000. If it's an ag assault with certain factors, it could easily be $10,000 to $15,000. Even if you go to a bondsman, lots of people can't afford $1,500. The next issue, and maybe the more serious one, is what is the relative risk of jail versus the community for this particular individual, for your loved one, for your family member? If we go back and they are only going to end up in the tangle, are they better off to stay in jail? With the reach-in that comes about now, your care team will be filing confidentially a continuity of care plan, which the jail can work from. Families' roles sometimes are better spent trying to get the loved one medication, at least in jail, stability in jail, get your loved one calmed down there, and then look at getting out. Because if you immediately bail somebody out, sometimes they just go into this, particularly if it's a domestic violence charge at this point, and they can't go home because that's where the crime occurred. Maybe the release order says don't return to the scene of to where the event took place. No contact with victims. Well, in our situation here, if the individual is living with a family because he didn't have housing or she didn't have housing, and there's the same supports are going to be in place, or they're going to go homeless, what's the likelihood that there's going to be more over here? And then we're looking at more charges. And if they're out on bail, then they're not going to be bondable when they get picked up again. So that's a problem. Now going back, we're back to here, and we're now over to this point. Hopefully, soon after the IA, they're going to get into a specialty court if they qualify. And they're going to be questions raised. Is the person competent? Were they insane at the time? And we're gonna now, here is where we get the beginning of the real meaningful programs that are in place in the criminal justice system right now to deal with mental illness, with defendants who have serious mental illness, and for whom this didn't work. So now we go over here. And this is why, of course, we have our jails nationally, our jails and prisons being the largest mental health providers in many states. They're the new asylums, right? Just with a different take now and a much more sophisticated, humane, informed approach. That said, most people believe that there's no way to get truly treatment, therapeutic treatment beyond medicines in a jail.
So Holly, there's a question.
Sure.
Can you request mental health court within all the different areas of Maricopa County? So if they're arrested and go to court in Scottsdale, can you ask that they be changed or diverted to a mental health court?
Most of our cities have mental health courts, and yes, you can. Your lawyer can. But if you're in the you're talking misdemeanors there. Mental health court does have criteria, and if you have had multiple failures and felony problems, more serious felonies, you're not going to be able to do mental health court. But every one of the cities, the municipal courts, I think all of them have a mental health court now. I just haven't been in all of them, but I believe certainly the first one was the one that Judge Ellie Finn created in Glendale years ago. And most of the cities have them. I'm not sure about some of the cities, Surprise and some others, but most of them do. And you certainly should be pushing for that if if that court is available. So here is where we get into specialty courts, and this is a different track. Remember, see, you may be in jail depending on your release conditions, depending on your bail, but you can be in a mental health court initially and while you're in jail. Otherwise, you'll go to dispositional court. Those are the regular superior courts, and you'll move forward. Now, the mental health courts, you're not going to stay in mental health court for long if you're in jail, but some of your preliminary issues can be handled and you may qualify for it. So that would be obviously good to get into that if you can. So going forward, the diversion and deferment programs, the county attorneys have the sole discretion, elections matter. Maricopa County, we've got drug diversion, felony pretrial intervention, and SMI felony. These two are now combined. The FPIP is post-charging. It uses cognitive behavioral therapy. It's for felonies 4 to 6. You have to have a minimal criminal history and a low risk to reoffend. The FPIP SMI program adds a community-based clinic that works with you in addition to the FPIP components, and they have additional programming, very important programming.
Well,
we have justice court. Okay.
We have a question. So when a person that suffers from serious mental illness does not comply with the requirements of, like, say, Tempe Mental Court, and they're sent back to regular court for regular penalties, does the mental health court keep such a person and customize penalties, including possibly some jail time based on the person's individual clinical situation? So if someone's not able to comply with a diversion court program, maybe due to their behavioral health issues, and they fail that, they're back to real court, real jail, and are the punishments as bad?
They can be. You can flunk mental health court, and then you go into superior court, into the regular one. I have a client who's now in prison who 2 years ago got new charges in the midst of a psychotic episode, but he did not qualify for GEI. And he got 3 major felonies. He had 7 or 8 misdemeanor cases that were all in mental health court. We worked and worked and worked. We had a great plan worked out. We got him released on his own recognizance to go into Valley Hospital. for a particular length of time. We got program in place. He didn't have housing, so he was having to live with an estranged girlfriend at her mother's house, and that ended up being on a porch, a screened-in porch, but he had a bathroom access and so forth, but that trashed his VSPADAT score, this housing score they use, because he had a roof over his head and a place to live, so he kept living there. He was out and he reoffended again even more significantly. And so he not only failed mental health court, but he failed and ended up with 5 felonies, class 3 and 4 felonies. We did a lengthy mitigation hearing, but he's doing double-digit years in prison.
Well, maybe a junior question. When you say felony 2, 3, 4, 5, is what's worse? Low numbers or high numbers? No, I mean as far as
a class 1 felony is the worst. That's murder. Class 2s, 3s, 4s, 5s, 6s. You move toward misdemeanors. An undesignated 6 becomes a misdemeanor at the end of a specified period of time, and that's great. Misdemeanors, 1 is most serious, 2 and 3 less serious. So we start at 1, which is murder, and for class 1, and we go, and many of our offenses, for instance, aggravated assault, can be a class 3, 4, or 5, depending on the circumstances. It's all in the slide we had earlier, which talked about what you did. Did you use a weapon? Were you hired to do it? And the facts and the circumstances. So you have to really look at the statute, read the elements, and apply. And most charges have multiple felony levels that can be associated with them. So on our diversion and deferment programs, Yavapai County, Sheila Polk's remarkable program is tied to crimes committed. Many of the individuals have mental illness, serious mental illness, but a strong nexus with substance abuse. And this is a program that provides, it's almost soup to nuts with housing and supportive services, and it requires accountability. You get your charges, your case dismissed, deferred, if you finish the program. Coconino County has a CBT program. They have some other programs that are even more current in terms of therapy for individuals with drug, substance abuse, and mental illness. They have a deferred prosecution program. Pima County has the DTAP program, which is drug treatment as an alternative to prison. They've got a felony drug diversion. They've got a big adult diversion program. So we have it all over the state. I picked just these 4 because they're the largest 4 cities that we typically, largest counties where we see things, and so I sort of chose those. Now moving on. Okay, we've gotten through our initial appearance, the arraignment we talked about earlier. One of the things that's good with when you're here and you're coming, you get into these early disposition courts, regional court centers. Early disposition is for people who are going to get probably no jail time, maybe a little jail time. It's a lot of more lower level felonies. What happens here, when you are in EDC, you can come in, and regional court as well, and you can have your status conference. And by the time you get to a preliminary hearing, because remember, this is charged on a direct complaint, you haven't been to a grand jury, you may have a plea offer. So you can go, you waive your preliminary hearing, and you go right down to plea. And this is really a nice way that the system was changed a few years back, and it works very well. And These courts are also, I think, a little more flexible at times. The commissioner's staff, the regional court center. I have a case at an RC, in one of the judges in the RCC. My client is seriously mentally ill. She has been in and out of treatment, outpatient, inpatient, in 4 states in the past 18 months. We have been able to work there with the prosecutors, 2 of them, and with the supervisor, and we're working on getting her healthy enough to get a plea that will permit her to actually have a plea to a Class 6 undesignated misdemeanor. This was an ag assault, flight on the freeway. Police, state troop, DPS responded. They threw out the spikes. She was completely in a complete psychotic break. And we've worked so hard on this case, but I am absolutely convinced that we're going to get her in a situation in 5 years down the road where she's not going to have a felony on her record, and she will have an F6 undesignated that will then become a misdemeanor. And we're looking at driving without a license, or I don't remember the specifics, but the county attorney's office has been absolutely wonderful working on this case, which was extremely challenging. She was in school, tried to get in school in Denver, for instance, in Colorado, and was picked up in the middle of the night, completely psychotic with no clothes on, walking through downtown Denver. She had similar episodes in other states. And, bless her heart, once she gets in treatment and she can stay in treatment, things get better. And then she relapses. The recovery road is bumpy and curved, but we've been working with the county attorney, and they have been absolutely wonderful in working with us there. So this is what happened, and this, I think, is very frustrating, and where all the delays come in. You have your pretrial conference, you have your discovery. That's each side giving the each other their information. This is the critical time for families to give as much information. Become advocates. You're the expert on your loved one's mental illness, as is your loved one. Get in there, get the lawyers, the information, the medical records, the reports, the history, everything about your loved one to paint the picture of the reality of this person's life with their living with serious mental illness. It's very powerful at a settlement conference. These are, in my mind, usually very successful. The exception here, I will say, is in cases that involve death, where you've had somebody and it's charged, it's either a first or it's going to be a second-degree murder case. Those are very difficult to move very far, with understandable reasons, since the loss, the victim's family, the social justice issues in maintaining a safe society against the most egregious crimes, then that is a whole different ballgame. And that's not really the focus of this presentation. We would have to really focus more on major crimes, on gang involvement, on gang involvement in capital cases. And I am not death qualified, meaning I don't try death penalty cases. I work on death penalty cases, usually on the mitigation side. But this is, with that exception, with those very major Class 1, Class 2 felonies, murder, homicides, and so on, the settlement conference can be extremely, extremely helpful. The final trial management conference is what happens right before trial, and then we have trial. Now, we're going to deal with Rule 11 a little bit later, so I want to just move on from there.
So Holly, one person's comment was their son's attorney pushed past what the family gave them in the settlement conference, and the attorney only spoke to prison supporting the officer statement. So
Well,
that's
odd.
yeah.
I would, I'm sorry. First of all, I'm sorry. That must have been painful and frustrating and hard to keep your temper. Um, Attorneys are not perfect, but you should feel free to call your attorney to task for not at least listening and not giving you the courtesy and the respect of an explanation of why the material wasn't provided and wasn't given prominence. I have had situations where I have a case now where the family is insistent on giving all of this information that goes back. We jokingly call them when my child lost his first tooth case, because they want to tell you about things that happened in Boy Scouts when they were 9 years old and Cub Scouts when they were 7. But I take that material, I put it in an exhibit as an appendix to my settlement conference memorandum, and I write a paragraph that says the clients, the defendants, or Joe's or Susie's or whatever. I don't call my clients defendant. I call them by their name. Susie's parents believe that what went on in her younger years when she was subjected to bullying, she was traumatized when she saw these are examples I've had. And so they have taken the time and put together Exhibit 2, which includes, and I list the following, and we respectfully ask the court to look at this and consider it in giving, working on the settlement at the settlement conference. And then we reuse the same material at sentencing in the sentencing memorandum and mitigation memorandum. Do I know if that sort of thing helps? I don't, but I know I owe that to my clients, especially the parents who are often paying the bill. I owe it to my clients' parents to take their information and to try to put it into a meaningful document. That's important information also to give to the psychiatrist or the psychologist that you're using to do your risk assessment, because they can use that kind of information to talk about the effects of childhood trauma, to talk about bullying, to talk about discriminatory behavior against them when they were in high school, and talk about the onset of the mental illness. And so the devil is in the details and the angel is in the details, right? And so I always take it, I always use it, I work it in somehow to acknowledge the importance to the client and to their family, and hope that it does a decent job. So specialty courts, I talked about them earlier, problem-solving courts. Those are the ones we just went through: the IA court, the early disposition court, we have a therapeutic drug and DUI court, veterans court, and of course the mental health court. And the municipal courts have all of the above and more. Phoenix now has a homeless court where they can have homeless people come in and to locations that are more convenient and not get failure to appear warrants. If you get, ticketed for urinating in public in wherever, and you miss your court date, then you're looking at a failure to appear. There's a bench warrant out for you. And although failure to appears are not rigorously enforced, it's still better. And so I think the fact that we have a homeless court is cool. I think it's very cool.
We have a question.
Sure.
If you're not a guardian and your loved one has not signed a release of information, can you usually get the clinical team to provide medical records to your loved one's attorney in the discovery process? I mean, what's their responsibility as the clinical team to help support your loved one, even if you're not guardians?
Yeah, I think that the attorney needs to have those records, and it's up to the attorney to get the client to sign a records release and get the records. If for whatever reason the client will not sign a records release so that I can get records, and I know that they're enrolled, say they're in an SMI clinic, they they have an assigned provider, they've got a treatment team, then this is right on track here. Is the defendant able to understand the proceeding being brought, the nature of the proceedings, and assist in his defense? If my client says, I don't understand why, I didn't think that person was, I didn't kill a person. I thought I was killing a dog. I thought I was killing a hornet. Well, clearly, I don't think he understands the nature of the proceeding. And if he won't give me medical records, he's not really willing to assist in his defense. I would, in all likelihood, file a motion for a transfer to Rule 11, unless there's something in the records that he doesn't want out for other reasons. There may be that maybe this person is active in a gang. I mean, if we're talking physical medical records, maybe he doesn't want anybody to know that he got shot and he was seen in the emergency room at Valleywise, and because people may not know that, his parents may not know that. And yet, if the medical records all come out, that may reveal that, and it may be to his detriment if his medical records reveal prior associations with these people that he's still involved with. But if it's a defendant, if it's a client who I think may not be getting it and doesn't understand how his clinical records can be helpful in mitigation, helpful in the settlement conference, then I would seriously consider a Rule 11 motion. And that's at any time in the proceeding. Competency is transient. I mean, we know that from people, your medicines are working great, you're doing fine, then you encounter stressors. Maybe the dosage is not quite right again. You stop taking it. I've had cases where a defendant was competent and not competent 2 or 3 times. And it's an interesting dilemma for attorneys, defense lawyers, because can you find the moment when the defendant is competent and you can get the really good plea signed? And can you keep him competent or her competent in order to get the judge to accept the plea and get him sentenced? So it raises lots of ethical and lots of professionalism questions. But at any point, I think for the lawyer, we have to say, what do I need to do to best represent the client? And if everything's been going along peachy and suddenly we need all of his medical records in order to persuade the prosecutor to give this really good plea, and the defendant says, no, I don't have mental illness, I've just been saying what they want me to say, I don't want to do this, I'll go to prison, it doesn't matter. Well, I'm not so sure. No, we're probably going to be visiting Rule 11.
So, Holly, again, what is Rule 11? What does that mean?
Rule 11 is the court to decide. It's a special court. It's a separate court. And unlike what happens in many courts, a lot of what happens in Rule 11 is confidential. So if at any point either the prosecutor or the defense counsel decide and question, is this defendant able to understand the nature of the proceedings and to assist in his defense, either prosecutor or defense can file a motion with the judge to transfer the case to Rule 11 court. The judge may grant it. It's not mandatory here. And that's a big difference with here and the federal system, because in the federal court, there's a different rule and the judge more or less has to do that. But once you're there, if the judge orders the case to Rule 11, it takes it off the active docket. It goes to a court with one purpose, and that is to determine competency. 2 experts are appointed, and it's from the Forensic Services list of approved evaluators, psychiatrists and psychologists. They evaluate the defendant. They reach a determination, competent or not competent. Their reports are confidential and filed under seal. However, what the individual says to the evaluator is discoverable if you then go for a guilty except insane plea. So generally, if you think your client is insane at the time of the commission of a crime and you intend to pursue GEI, you don't have them evaluated because you never know what's going to be said, right? Competency is transient, and you don't run the risk of creating a bad record, bad in the sense that it would undermine a GEI defense. So, next step, the two experts see the individual and they both come back and they say, yes, competent. You go back to the regular docket, or you can challenge it, but that's tough. You go back to the regular court. They say no, then the question is he restorable or she restorable? The experts say, well, maybe. What do I mean by that? One says yes, one says no. So we have a tiebreaker. The court appoints a third. If they come back and say not competent, then the client goes into competency restoration, which is an oxymoron sometimes, if there ever was one in our restoration program. It has been the Competency Rule 11 program is constantly under study, constantly under review, constantly under revision and improvement. It is a difficult area of the law and a difficult area of science and medicine. And it's continually evolving. If you're not competent and you go into competency restoration, if you're in custody, if you're in jail, then the restoration to competency program is run by Correctional Health Services. And I respect their efforts. I respect what they are trying to do, but I have to say, I don't like it.
Not a fan. Okay.
Not a fan. Mainly because it is not nuanced. It's an education program to teach a defendant to be able to say, a judge will preside over the trial, and if a jury finds me guilty, the judge decides the sentence, and my lawyer's job is to work for me and get me the best deal, and the prosecutor's job is to prosecute the case. And if you can say those things, even if you have memorized them by rote, then you're competent. And that does not, in my mind, mean you can assist me in putting on a meaningful defense, particularly of a complex case. But it is a difficult area. If you're not restorable, then the judge can order a Title 36 petition for court-ordered treatment be filed. They can order a Title 14 petition for guardianship or conservatorship. They can order the defendant released and charges dismissed without prejudice. And I have a client who was assaulted by another individual who was at ASH. They were both at ASH. My client was assaulted by this other patient. The other patient had committed murder and was sentenced to ASH, but was found not competent, not restorable. Then in the community became restored, and because the charges were dismissed without prejudice, he was then recharged and sent to ASH. So this happens, but it is extremely complex. So we're back now. We finished this and we're over to the plea agreement and then to trial. The plea agreement is where the most work goes on in trying to reach a resolution and in trying to get a mitigation. So let's talk about that. Mitigation, remember, we have a sentencing chart that takes your criminal history, what you're charged with, adds mitigating factors and aggravating factors, which we'll talk about now. And you're within this box, and the judge can only give you a mitigated or an aggravated, but you're moving within the same box. The difference could be something like 7 to 10 years. That's a big difference, but it's not going to be 2 years or 15 years. All right, you're moving within a box. At sentencing, a judge considers age, and then here's the key factors about cases in which mental illness played a key role. It's not a defense to your crime, but what was your capacity to appreciate wrongfulness? Was your ability to conform your conduct to the requirements of the law, like not touching somebody's hair, not hugging somebody who doesn't want to be hugged, was it significantly impaired? Were you under some sort of duress? Minor participation in the crime is if you're very interesting here. Were you persuaded by people who took advantage of you as someone with mental illness to get you to do something like, oh, ride the bicycle down and give this package to the guy 5 blocks down the road, and it turns out to be a drug deal? Okay.
But they're getting a pack of cigarettes, right?
Exactly. Buying it, exactly. And then here's the catch-all, and this is why I want the 3-ring binder, or the CD now that we have, with all the parents' information and all those appendices. Any other factor, background, circumstances that can be mitigating. So I think that there are lots of cases where that comes in, and we spend a huge amount of time writing mitigation memos and sentencing memos for our settlement conference or the trial. Now, by the same token, while we have these few statutory things for mitigation, so we've got 1, 2, 3, 4, 5, about 6. Well, aggravation, we have 27 factors and sub-factors. So the only way I remember it is like who, what, when, where, without reading the statute every time I have to look at it. Aggravating factors can be your characteristics. Are you a prior felon? Were you a fiduciary for somebody, court appointed, and your crime involved taking advantage of that? Were you hired to commit the crime? Does not look good for mitigation if you were a hired gun. Your tools. Did you wear a mask? Body armor? Did you use weapons? Surprise. This means you hid in wait and jumped out to shock and take the person by surprise. That's an aggravator. The characteristics of your victim, the elderly, police officers, all sworn peace officers, the family of the deceased, the nature of your crime, if you were involved in trafficking, international trafficking, intentional pain and suffering, that's torture, hate crimes. So these are the characteristics, but there are 27 of them, along with their subparts. And then, of course, the catch-all, other circumstances that the court deems pertinent based on the defendant's character, history, or other relevant factors. So somewhat snidely, I refer to this as the Hitler test. If what you did is kind of like Hitler, it's going to really be aggravating. Or maybe it's the Charles Manson test. He might not have worn mask, a body armor, etc., but it's going to be aggravated. And the court can find and can use all those features of the defendant, how it was carried out, the victim's characteristics, and the nature of the crime, and aggravate it. And that can add years to a sentence. It also has an effect when we are talking not directly under the code, but these kinds of facts have a huge effect if you're charged with multiple counts that can be served consecutively or concurrently. In other words, you get 3 years and 5 years, so you serve 8 years, or you get 3 years and 5 years and you serve 5 years. That's a huge deal as well. So now,
Holly, just
yes.
As a time check, we're at 7. I think it goes on, but if you want to, we'll move on to this.
Yeah, we'll wrap up. The wrap up.
We have time, so we can continue to record unless, hopefully it doesn't stop at my 2-hour limit. We'll see, fingers crossed.
So
okay.
We're to the last 2 slides. The failure right now, in my mind, of us dealing effectively with many individuals with serious mental illness is that they are overrepresented in our criminal justice system, and much of that overrepresentation, the higher prevalence, relates to substance abuse disorders. Nationally, this is from SAMHSA, if they did a national test of drug testing of arrestees in county facilities, 80% of the people were positive of the individuals with serious mental illness. When you come over here in the population, the jail, in custody, 68% have a substance abuse disorder, 22% SMI and substance abuse.
Well, that's a good question. If there's such a high prevalence of substance abuse in jail, do they have really good effective treatments?
No, they don't. No treatment in Maricopa County unless you are in the mental health unit, but you're in the mental health unit not because of your substance abuse, but because you've got a very serious mental illness that causes, and your conduct is such that you are a real danger to yourself and to other people. So that's why you're there. So no, there's not much effective, if any, drug abuse treatment. So let's look at this. This is what's fascinating too. In the general population, only 4% of the population is believed to have serious mental illness. In the jails, 17% have serious mental illness. And of the 17%, 72% have co-occurring disorders. We can't fix our justice system's handling of individuals with mental illness unless we more effectively and in a much more nuanced way deal with substance abuse. And that brings us right back to the conclusion with the Goldstein Triangle, which I still think is one of the best graphic representations of the challenge of how we reduce the prevalence of jail inmates who are seriously mentally ill, and how we go back and improve the very first slide that we had on the intervention at the beginning in the community level, and when people come out of prison after sentencing on the other end and go back to the community. That is what this slide is about. And so the question, what do I do? My loved one who has mental illness has been arrested. The shortest answer is get the best defense you can and then try to sort this out. If we could make this as linear as we make our court system, we wouldn't have the problem, right? But it all, for me, hinges right here. The most common intercept is law enforcement. We've made enormous progress, but this is the key, I think, to flattening this out and working with law enforcement and holding the rest of this huge system in this tangle accountable for a more effective system to diminish the prevalence, the incidence and the prevalence of law enforcement, of justice system involvement with the seriously mentally ill individuals who are trying and sometimes simply cannot conform conduct to what the law, particularly in Arizona, requires.
So Holly, there's some question. First, there was a discussion that there's a program called Mosaic that's being offered for drug treatment, and
that is
some
true.
feedback. It looks like it's well, but another question: are people generally drug tested at the time of arrest and booking, or any subsequent time? I would think in jail you couldn't get drugs, but call me naive, right?
I'll call you naive. More so in prison, but certainly yes. You're drug tested at booking at the initial intake assessment. Particularly, I think everybody is. But I may be wrong there. But certainly, if there's any suspicion of any sort of conduct disorder, then any sort of aberrant conduct they're going to test, and that's important because you want to know if drugs can be an explanation, but it's now almost never the explanation, and that's where we tend to deviate from best practices by assuming that the fact that somebody's positive means that all of their conduct is due to drugs and none of it is due to a mental illness for which we can provide treatment and therapeutic intervention and diminish that conduct. we have a ton of questions which people had submitted in advance. And so what I will do is I will write a short answer. This will be like a short answer, a short question quiz, right? I will write a short answer to each of these. We have phone numbers, for instance, for how you find the location in the jail, how you find out the charges. We've got numbers that at least are current now. They may not be. And I'll just give a warning here. My husband just came home, and so you're going to have a pit bull and a beagle start barking any moment now because they're going to go into squeals of joy that he's home. So we've got all these questions. I'll write short answers, and we'll put them on the website.
Okay, thank you very much, Holly. That was very informative. I think that what we'll do is we'll have the video up sometime tomorrow. We'll have the slide deck with answers to these last questions, and I'll send you guys a email with links to both as soon as I get them uploaded. But if you want to go off mute, let's thank Holly.
Thank you, Holly. That was a great presentation. I really appreciate it.
Thank you for sitting in.
Thank you very much.
Thank you.
Thank you, Holly.
Thanks, Holly.
You are all welcome. Thank you for
Thank you so
participating.
much.
Thanks. Well, thank you, Holly. Have a good night. Go
too.
greet
Everybody
your dogs
be
and
safe.
husband.
Yeah. Be safe, everyone, please. Bye.
Thank you. Bye.